meu nome é Luca Belli, eu sou um professor da FGV Direito Rio, vou ser o moderador dessa sessão satélite, desse evento satélite, pelo menos a primeira sessão desse evento satélite da CPDP Latam, organizado na ocasião da Global Privacy Assembly, a conferência dos reguladores da privacidade de dados pessoais do mundo, que está sendo sediada pela autoridade da Turquia, em Istambul. E, na ocasião dessa conferência, que começará amanhã, decidimos organizar um pequeno evento satélite por duas razões. De um lado, ter uma primeira sessão com formato multissetorial para discutir alguns dos assuntos que foram identificados como os mais relevantes, urgentes, ao longo da CPDP Latam, que foi sediada aqui no Rio de Janeiro, em julho, uma conferência com grande sucesso, uma grande participação, e alguns dos assuntos mais urgentes que foram destacados foram justamente a governança da inteligência artificial, a superposição entre esse assunto, governança de IA, com proteção de dados, e transferência de dados, regulação e transferência de dados. Para aprofundar esses assuntos, hoje vamos ter 3 sessões. A primeira, com um formato multissetorial, como eu estava falando, que será aberta pela relatora especial da ONU, nossa amiga querida Ana Briand. Depois, vamos ter o secretário de Proteção de Dados do INAI, o Instituto Nacional de Transparência, Acesso, Informação e Proteção de Dados do México, o Jonathan Mendoza. Seja bem-vindo, Jonathan. Depois vamos continuar com a professora Laura Mendes, que é professora do CEDIS, no IDP, e também relatora da Comissão sobre IA do Senado Federal do Brasil. E depois vamos continuar com algumas análises um pouco mais detalhadas, casos de estudo, perspectiva também do setor privado, com a Paula Vargas, que é diretora de políticas públicas de privacidade da América Latina no Meta. Depois, o Daniel Stivelberg, que é o coordenador do Grupo de Governança de Dados da Zeta, que é a Associação de Fintech do Brasil. E depois, last but not least, claramente, o nosso amigo Lee Matson, que é Senior Counsel no Future of Privacy Forum. Aí, antes de começar, também queria destacar que depois dessa sessão multissetorial, vamos ter mais 2 sessões que serão moderadas pelo professor Nicolas Ingales, da FGV, e pelo professor Ivar Hartmann, do INSPER, nas quais serão apresentados os resultados da pesquisa desse ano da CPDP Latam. A gente elaborou 2 números especiais de 2 revistas de muito alto nível, com elevado impacto internacional, a Computers Law and Security Review, CLSR, com um número especial dedicado à proteção de dados e inteligência artificial na América Latina, em inglês, e depois um número especial da Revista Brasileira de Direitos Fundamentais e Justiça, também uma revista com um impacto muito elevado ao nível nacional no Brasil, então com contribuições em português e em espanhol. A razão, como estava falando, pela qual resolvemos organizar esse evento de hoje é justamente analisar a superposição desses 3 assuntos cruciais: governança de IA, proteção de dados e regulação de transferências internacionais, que impactam basicamente cada assunto cotidiano, seja serviços privados, seja acesso a serviços públicos, tomada de decisões, que cada dia mais é automatizada e baseada em processamento de dados não somente pessoais, mas principalmente dados pessoais, que podem ser considerados como um verdadeiro insumo da inteligência artificial, alimentam e geram a insight que é produzida para o processamento algorítmico, os sistemas de IA, que depois permitem uma tomada de decisões frequentemente muito mais eficiente, mas também criar alguns riscos. E vários desses riscos, esses benefícios foram explorados ao longo da CPDP Latam em julho, e alguns dos pontos principais que foram destacados, primeiramente, foi a necessidade de uma cooperação ao nível da América Latina, idealmente global, Mas o que é essencial é o que a CPLP Latam almeja proporcionar é uma cooperação, uma plataforma de cooperação latino-americana. Estamos testemunhando a emergência também de alguns exemplos, como, por exemplo, a recente publicação pela Rede Ibero-Americana de Proteção de Dados de um guia com algumas cláusulas padrões para a transferência de dados internacionais, e porque esse ponto das transferências de dados é particularmente interessante e essencial pelo funcionamento de sistemas de IA e para o funcionamento de plataformas para a tomada de decisões automatizadas, porque transferência de dados não significa necessariamente pura e simplesmente o acesso de dados, o envio de dados de um país para outro, mas simplesmente o armazenamento de dados num país terceiro, coisa que acontece em basicamente todos os processamentos de dados, com o uso de plataformas e serviços de armazenamento estrangeiros. Essa mera transferência, esse mero armazenamento de dados num país terceiro implica transferência de dados. Então, basicamente, qualquer processamento de dados automatizado e armazenamento de dados num país que não seja o país no qual os dados são coletados, implica transferência de dados. Então, a inteligência artificial, o funcionamento da inteligência artificial, da automatização, do processamento, do tratamento de dados, na maioria dos casos, implica também transferências internacionais. Claramente, todos esses assuntos têm um impacto enorme, não somente sobre a proteção de dados dos indivíduos, mas sobre o desenvolvimento social, democrático, econômico da região, não somente do Brasil, mas também de todos os países da América Latina, né? Vamos ver também que o Brasil é praticamente na vanguarda na proposta de um marco regulatório de IA, mas tem muitas críticas que também podem ser feitas nessa proposta, e vamos falar disso com a nossa amiga Laura. Então, sem querer falar demais, que é um dos meus piores defeitos, eu vou passar a palavra diretamente à nossa amiga Ana Bayan. É uma grande honra, Ana, estar aqui com você de novo. Por favor, seja bem-vinda. Como se fala em bom português, the floor is yours. Obrigado, Ana, para destacar o valor essencial do respeito pleno dos direitos fundamentais, direitos humanos, na elaboração, na produção de novas tecnologias, de novas arquiteturas técnicas, mas também regulatórias, organizacionais, da tentativa, inclusive, da tentativa em vários marcos regulatórios nacionais. Essa nem é uma tentativa, é uma obrigação de embutir o respeito da privacidade e da proteção dos dados nas arquiteturas técnicas e organizacionais que os diferentes controladores, os diferentes gestores de dados desenvolvem para estruturar seus sistemas baseados em coleta de dados. Aí, vamos ver, nesse sentido, como o INAI, o regulador da proteção de dados e também do acesso à informação do México, conseguiu já desenvolver alguns princípios e se adiantar na regulação, ou pelo menos na sugestão de algumas linhas diretrizes para orientar não somente as transferências de dados, mas, sobretudo, também a aplicação dos princípios de inteligência artificial em compatibilidade, em conformidade ao marco regulatório de proteção de dados do México, que, lembramos, é um dos mais antigos da região, né? Então, por favor, é um grande prazer ter Jonathan Mendoza conosco hoje. Por favor, Jonathan, the floor is yours.
Buen día, Luca. Muchas gracias por la invitación a CPDP Latam. Es un gusto, es un privilegio compartir este panel con personalidades muy reconocidas. Buenas tardes desde Estambul. A punto de iniciar ya la sesión abierta el día de mañana de GPA en su edición 44. Ya la doctora Ana Bryan, a quien aprovecho para saludar en esta vía virtual, nos ha dado un contexto y un antecedente muy claro de cómo se van desdoblando los temas hasta llegar al tema de CBPRs. Déjame saludar, Luca, tenemos poco tiempo, pero siempre hay que ser educado. Hola, Paula, qué gusto compartir contigo aquí. Daniel, Laura, ¿cómo están? Lee, muy buenos días para ustedes. Y básicamente quiero contextualizar. ¿Qué buscamos? Aprovechando que ya dio un marco muy importante la doctora Ana Bryan. ¿Qué buscamos? Convergencia normativa. Buscamos un estándar, Luca. Ese estándar tiene distintos mecanismos para conseguirse. El principal es la adecuación, por supuesto, ser considerado un tercer país adecuado. La más famosa o la más conocida, pues es la adecuación otorgada por la Comisión Europea, a través de este mecanismo que hay en el artículo 45 y subsecuentes del Reglamento General de Protección de Datos de la Unión Europea, GDPR. En la región, ¿quién tiene nivel de tercer país adecuado ahora? Pues Argentina y Uruguay. Los dos lo tienen con la Directiva 9546. Ambas adecuaciones están siendo revisadas en este momento por la Oficina de Flujos Transfronterizos de Datos Personales encabezada por Bruno Giancarelli. Y nada más, nadie más tiene ese nivel de tercer país adecuado. Por supuesto que si vas hacia el esquema complementario internacional del convenio 108, pues ahí puedes incluir a México, pero el 108 es de 1981, tiene 41 años, ¿no? Pero Argentina, Uruguay y México forman parte del 108. Ya firmó Uruguay, tierra de Ana, el 108 Plus o el protocolo 223, y la tierra de Paula está cerca de hacerlo, aparejado de una reforma legal importante a su regulación que tiene por ahí de 22 años, ¿no? En fin, México está en ese proceso desde 2020, febrero de 2020, y estamos esperando un poco la respuesta que pueda haber respecto a la Comisión Europea, pero hay que decir algo más. Este es uno de los escenarios posibles para generar convergencia normativa, el tema de Europa. Hay otros abiertos, otros que ya existen. Por ejemplo, APEC, el sistema APEC, formamos parte de él hace más de una década, tiene base TEMEC en APEC y OCDE, el Tratado de Libre Comercio entre México, Estados Unidos y Canadá, y ustedes saben de la creación del Global CBPR Forum. que es reciente, es de abril de este año. Hubo un foro la semana pasada en el cual participaron algunas autoridades de Estados Unidos en la Universidad de Externado de Colombia, y yo preguntaba, ¿cuál es el estándar? ¿El estándar es distinto de APEC o no lo es? ¿Es mayor? Parece hasta este momento que el estándar es el mismo de APEC. No es porque sea malo el estándar de APEC, lo que pasa es que no es el estándar más alto que hay. Y así como eso, habría que voltear hacia otras latitudes, creo yo, Luca, como Reino Unido o incluso el tema de Dubái, que acaba de conseguir Colombia esta adecuación, pero eso porque las regulaciones lo prevén, esa posibilidad de ser determinado como un tercer país adecuado. Pero el mensaje más importante que me gustaría dejar es que además de voltear hacia otras latitudes, otras regiones, creo que tendríamos que empezar a valorar esto hacia LATAM, hacia Latinoamérica. Es decir, cómo construimos un estándar en Latinoamérica que sea compatible o comparable con otras latitudes. Eso creo que lo hemos dejado de hacer o que no lo hemos hecho correctamente con el tema del estándar de adecuación, porque si ustedes se dan cuenta, Argentina y Uruguay tienen este estándar muy bueno, pero digamos, no de análisis de fondo de cada una de las adecuaciones hacia los países que forman parte del listado. Si no es el listado, parecería que es el incorporado de la Comisión Europea, no uno propio. Se asume como propio, pero no hay un análisis de fondo. En el proceso hay peticiones de Colombia para Uruguay, sí, de ser adecuados, de Colombia hacia Argentina, y ese proceso entre países creo que lo tendríamos que empezar a valorar. Claro que hay mecanismos secundarios, tú ya decías uno de ellos, las cláusulas contractuales tipo, y para temas de empresas internacionales y grupos corporativos, pues Binding Corporate Rules. Lo podemos hacer de esa manera y con legislaciones locales también para complementar. Pero lo que está hasta arriba es el estándar internacional que busca convergencia normativa, que busca hacer una forma de habilitar economía digital en la región y de no obstruir en nada la economía, pero sí siendo un factor a considerar. ¿Cómo está evolucionando esto en temas de tecnologías disruptivas o tecnologías emergentes? Pues claramente con esquemas como las PETs, ¿no? Privacy Enhancing Technologies, que es una forma de aterrizar o implementar principios que tienen también más de una década, privacidad por diseño y por defecto. Recordarán esa resolución de Jerusalén de 2010 de GPA, cuando era la conferencia de autoridades y no GPA, donde Anne Cavoukian fue una de las impulsoras de este tema. Yo creo que cubrí mi tiempo, espero haber transmitido el mensaje de una manera adecuada. De Privacy Enhancing Technologies puede hablar mucho mejor Paula, estoy seguro, y también Lee, y acá estoy a sus órdenes para cualquier pregunta.
Muito obrigado, Jonathan. Excelente também descrição histórica da evolução desse tema, que claramente está se tornando algo de essencial do ponto de vista não somente de regulação de dados pessoais, mas também de política industrial nos últimos anos, mas que é um tema que está sendo debatido para especialistas de proteção de dados e de governança de inteligência artificial há pelo menos uma década. Então, é muito bom também destacar que, apesar de ser algo de extremamente relevante hoje em dia, não somente pelo futuro do desenvolvimento tecnológico, mas também pelo presente, é algo que já foi debatido bastante no passado, pelo menos ao longo da última década, né? Aí, estamos já vendo alguns exemplos de como essa cooperação internacional, de um lado, poderia ser organizada. Eu mencionei antes aquele guia sobre cláusulas padrões para transparência internacionais. Estamos vendo alguns exemplos também que estão sendo liderados para organizações nacionais, como o INAI, por exemplo, e também estamos vendo alguns exemplos de legisladores nacionais que tomam a iniciativa de regular inteligência artificial. A nossa amiga Laura Mendes, que desde o início também foi uma grande apoiadora da CPDP-Latam, ela é a relatora da comissão do Senado de juristas, que está suportando a elaboração, a estruturação do projeto de lei sobre o marco regulatório de IA no Brasil. Então, por favor, Laura, estamos muito curiosos de entender quais foram as recentes evoluções e o que podemos esperar desse processo normativo nos próximos meses. Por favor. Muito obrigado, Laura. Excelente ver também esse nível de transparência e de participação do lado da Comissão do Senado, algo que claramente estava faltando na visão da enorme maioria dos especialistas antes da criação dessa comissão. Na verdade, eu convido também para quem for interessado nesses aspectos, para quem for interessado em entender o porquê foi tão necessária a criação dessa comissão, da qual a Laura é relatora. Estamos publicando entre os produtos de pesquisa da CPDP-Latam desse ano, um artigo que eu tive a honra de escrever junto com os meus coautores, Walter Brito e Yasmin Kursi, sobre justamente a análise da proposta do marco regulatório brasileiro sobre IA e em quais medida essa proposta podia deixar muito surpreso um observador, não somente pelos elementos muito pouco definidos da proposta atual, que está sendo aprimorada pela comissão, mas também às vezes, falta de consideração ou até vontade de utilizar os elementos que já existem, não somente do lado da LGPD, mas também os elementos de governança, os comitês sobre IA e inteligência artificial que já existem nas instituições governamentais que foram criados como resultado da estratégia de inteligência artificial que foi aprovada o ano passado, né? Então, para quem quiser, eu acho que essa leitura, para quem quiser ter uma boa ideia do que está acontecendo, do que aconteceu até hoje e do que vai acontecer provavelmente no futuro, eu sugiro muito calorosamente de ler esse artigo que será publicado hoje e depois consultar com muita atenção o site da Comissão do Senado que a Laura mencionou, porque é uma riqueza incrível de documentos, de gravações, de material, que acho que também é uma boa prática no sentido de como deveria ser um processo participativo multissetorial de policy making. Dito isso, a gente tinha planejado de ter uma pequena parte uma pequena secção de perguntas e respostas no meio dessa primeira sessão, mas considerando que a gente começou com 20 minutos de atraso, eu passaria diretamente a próxima palestrante, a Paula Vargas, que eu sei que tem também uma agenda bastante densa, e a gente vai seguir com as intervenções dos palestrantes para depois abrir para questões no final. Então, Paula, por favor.
Muchas gracias, Lucas. Sí, yo ya estoy en Turquía, como otros colegas que también están acá, y empezamos a tener ya actividades hoy, así que pido disculpas si tal vez tenga que retirarme un poquito antes de que termine el panel. Bueno, ¿me escuchan bien, no? Sí, bueno, muchísimas gracias por la invitación. La verdad es que, nada, he tomado muchísimas notas de todo lo que se dijo. Y bueno, obviamente yo vengo a traer la visión de una compañía para la cual la inteligencia artificial está en el centro de todo lo que hace. Digamos, es difícil, de hecho, pensar en algún producto de Meta que no haya sido transformado por la inteligencia artificial. Pensemos, por ejemplo, que nosotros procesamos tal vez trillones de operaciones diarias para que los 2 billones de usuarios que están aproximadamente, que están en Facebook, puedan encontrar el contenido que realmente les sea relevante. De los miles de posts que podrían recibir cada día, bueno, ¿cuáles son los que les son relevantes? Eso requiere, obviamente, el uso de inteligencia artificial. Nosotros tenemos 3.5 billones de usuarios mensuales, si pensamos en WhatsApp, Messenger, Facebook e Instagram. Son números realmente, bueno, muy impresionantes, ¿no? Y eso, digamos, nos lleva a pensar en el grado de conectividad sin precedentes que tenemos hoy. ¿no? Las personas que usan servicios como los nuestros, que encuentran ideas, noticias, comunidades, negocios, que no están constreñidos por barreras locales o nacionales. Como les decía, este es un grado de interconexión humana que no tiene precedente en la historia. Pero por otro lado, la inteligencia artificial y el machine learning ya no son el dominio de compañías tecnológicas. La proliferación de bases de datos accesibles no es solo un beneficio para la economía global o para la sociedad global, sino que ha nivelado en cierta forma el campo entre grandes corporaciones y pequeñas empresas. El Big Data, digamos, el llamado Big Data, trae todos estos beneficios, pero como siempre discutimos en cada uno de los paneles que tenemos la suerte de compartir, ha traído también riesgos y ha traído muchos dilemas. Y tal como los cambios tecnológicos previos, las sociedades necesitan acordar los parámetros dentro de los cuales la tecnología va a poder operar. Y esto significa establecer las salvaguardas que permitan potenciar lo bueno y mitigar lo malo que pueden traer. En esta discusión que recién bien describió Laura, un ejemplo muy concreto de cómo se está dando esta discusión multi-stakeholder y esta discusión de una política concreta, en el medio de esta discusión hay conversaciones sobre, por ejemplo, localización de datos. Estas conversaciones sobre localización que implican, bueno, la idea de que una nación puede restringir o frenar la circulación transfronteriza de datos, es una discusión hoy común y que se van incluyendo también en leyes, y lo que esto ocasiona es que cada una de estas restricciones en cierta forma va minando los fundamentos de una Internet abierta. Una Internet abierta se basa en una circulación de datos transfronterizos, y es importante recordar que las redes de Internet son agnósticas en términos de transmisión física. Entonces es importante que esta discusión de cuáles son las nuevas reglas para el Internet, las muy necesarias nuevas reglas para el Internet, se den basadas en premisas que no estén erradas sobre qué son los datos y cómo crean valor los datos. Porque podemos considerar esto un impulso natural de los gobiernos y comprensible también, y más cuando ven que otros hacen lo mismo, sentirse atraídos por esta idea de que establecer barreras digitales en sus fronteras puede impedir que los datos sean extraídos para ser utilizados por intereses poderosos basados en otro lugar. Pero esto lo lleva por ahí a eso que tanto hemos escuchado nosotros de que los datos son el petróleo. El tema es que hacer ese tratamiento en la discusión de una política pública lo que lleva es primero ignorar que los datos tienen beneficios, el beneficio de los efectos de red, ¿no?, en la circulación de datos. Y por otro lado, por ahí ignoran que el dato es algo completamente diferente en cuanto a que la capacidad de valor que tiene un dato está esencialmente ligada a que pueda circular, ¿no?, de forma transfronteriza. Entonces, quería poner esto de relieve para decir, bueno, no es tan simple que más datos es más valor, no necesariamente. El valor de los datos está ligado, como también dijo alguien aquí, a los insights, a la información que puedan producir. Y por supuesto que el valor de los datos es enorme para quien tiene la capacidad de usarlos, sea una compañía tecnológica de Silicon Valley, sea un ministerio de salud, sea un fabricante de autos en Alemania o una organización de la sociedad civil. Recolectar, almacenar y analizar datos a gran escala es muy valioso cuando los datos son de alta calidad y cuando se sabe cómo extraer esos insights, pero no es un recurso natural escaso y no está limitado a cuántas veces se lo procesa. Entonces, obviamente Meta tiene un interés en este debate. Nosotros somos una empresa global cuyos servicios dependen de esta capacidad para almacenar, transferir y procesar datos a gran escala. Pero no somos la única, incluso si nosotros no estuviésemos, Millones de negocios comparten datos de forma transfronteriza y millones dependen de servicios basados en datos. Estos productos ya son parte de las experiencias diarias de las personas y los negocios, incluyendo, por ejemplo, la investigación académica. Entonces, el riesgo es que con cada restricción local, la Internet se vuelva un poquito menos libre y la economía digital un poco más restringida. Y entonces, ahí es donde estas discusiones que todos estamos teniendo son muy importantes para precisamente establecer cuáles van a ser las salvaguardas, por ejemplo, para la privacidad. Discusión fundamental, ¿cómo salvaguardamos la privacidad en esta transferencia sin crear barreras? Entonces, ¿cómo creamos salvaguardas? Lo que no es lo mismo que crear barreras. Y ahí quiero cerrar con dos ideas, que también se habló un poco acá. Una es la cooperación internacional. Es muy importante la cooperación, es más importante que nunca, ya que se juega un rol muy importante para proteger el futuro de una Internet abierta. Y ahí, trabajar con Naciones Unidas, por ejemplo, los gobiernos pueden trabajar juntos en mantener la infraestructura técnica del Internet, ayudar a conectar a los que aún permanecen desconectados. No podemos olvidarnos de eso. Hay muchas personas que aún están desconectadas. Y por último, hacer referencia a algo que mencionó el doctor Mendoza, que yo no creo que lo pueda explicar mejor que él, pero puedo hacer mi contribución, que son las Privacy Enhancing Technologies. ¿Por qué traemos este tema a esta discusión, que parece de más alto nivel? Porque es una forma también de insertar la privacidad y de automatizar decisiones de privacidad en el funcionamiento de la inteligencia artificial. Laura había mencionado decisiones automatizadas, toda la discusión que se está dando sobre decisiones automatizadas. Entonces, cuando nosotros insertamos una tecnología que puede ser anonimización, privacidad diferenciada, hay muchas técnicas distintas, lo que estamos haciendo es automatizar decisiones de privacidad que ayudan a la minimización, que ayudan a la limitación de la finalidad y a todos los otros principios que conocemos en materia de protección de la privacidad. Entonces, creo que se me dio el tiempo, no quiero sacar mucho más tiempo, pero quería dejar este mensaje de lo importante que es discutir las nuevas reglas del Internet basados en concepciones de lo que realmente son los datos, de cómo realmente se extrae el valor de los datos, de la importancia de la transferencia a través de las fronteras para poder extraer el valor de esos datos, para beneficio global, y cómo creamos juntos las salvaguardas para que esto, por supuesto, se haga protegiendo la privacidad. Muchas gracias.
Muito obrigado, Paula. Claramente, eu acho que mais um ponto que está ficando extremamente claro na conversa de hoje, no qual eu acho que tem muita convergência, é essa necessidade de cooperação. Eu acho que um ponto que cabe também lembrar é que a necessidade de criar mecanismos de adequacia e lei de localização de dados é algo que surge na falta de um marco regulatório internacional com regras comuns, né? Se existisse uma convenção global sobre proteção de dados, com as mesmas regras, mesmas garantias, mesmas obrigações, mesmos direitos para todos no mundo, não seria necessário nem desejável criar restrições. Essas restrições existem também porque tem níveis muito diferentes de regulação. Então, por exemplo, não existe restrição entre França e Bélgica porque tem a mesma normativa, o GDPR, mas podem existir restrições entre Brasil e outro país da América Latina porque não tem a mesma normativa. Então, essa tentativa também que a LCPDP está proporcionando de criar uma plataforma para debate e também, idealmente, a partir do ano que vem, essa é uma notícia que eu tenho o grande prazer de anunciar também hoje, que muito provavelmente, a partir do ano que vem, teremos uma escola de governança de dados da América Latina, que vamos criar como um spin-off acadêmico da CPDP-Latam, justamente para fomentar pesquisa e convergência na pesquisa e nas políticas públicas ao nível da América Latina, para digamos, trabalhar mais nas convergências e achar pontes entre os vários, criar, se não achar, pelo menos criar pontes entre os vários marcos regulatórios ao nível latino-americano. Vamos passar com um outro caso de estudo que eu acho extremamente relevante, justamente porque estamos falando de empresas, de startup, muito inovadoras, fintech, que estão revolucionando o panorama social, não somente econômico, não somente ao nível brasileiro, mas ao nível da América Latina, criando, trazendo pela primeira vez, talvez, para milhões de pessoas, a possibilidade de ter uma conta num banco, a possibilidade de utilizar serviços financeiros. Então, o Daniel Stiverberg, que trabalha pela Zeta, a organização que associa essas fintech e startup inovadoras no âmbito do serviço financeiro, é talvez a melhor pessoa para nos apresentar também são não somente os grandes benefícios dessas inovações, mas também os enormes desafios em termos de regulação, sobretudo no que diz respeito às transferências de dados. Por favor, Daniel. Excelente. Muito obrigado, Daniel, pela excelente fala, muito detalhada, traz no debate muitos elementos essenciais. Primeiramente, o fato que, quando falamos de inteligência artificial, precisamos também considerar que existem sistemas extremamente diferentes. Não estamos falando somente de redes sociais, estamos falando de fintech, estamos falando de um leque extremamente amplo de sistemas muito diferentes, por isso que é essencial também ter um cuidado aprimorado no esforço de entender de quais sistemas estamos falando e como mudam as coisas, também como muda a relação com a proteção de dados, e também quais seriam as estratégias para criar uma melhor interface entre o setor específico que está sendo automatizado, que já foi automatizado para uma governança de IA já existe, como por exemplo no caso das fintech, e o setor que em alguns lugares, sobretudo na América Latina, ainda nascente da governança de IA. O que você mencionou, outro ponto essencial das sandbox regulatórias, essa é claramente uma estratégia extremamente interessante que pretendemos analisar com certeza na nossa atividade pedagógica, digamos, que vai começar o ano que vem sobre a escola latino-americana de governança de dados, mas vamos claramente atualizar vocês todos, não somente nas redes sociais, no nosso site PDP Latam, sobre as evoluções desses pontos. Agora, para terminar, a cereja no bolo é o nosso amigo Lee Matson, do Future of Privacy Forum, que tem trabalhado de maneira muito extensiva com os seus colegas sobre regulação de IA, transferências internacionais e basicamente qualquer assunto de governança de dados pessoais, inclusive automatização. Por favor, Lee, the floor is yours. Lee, sorry for the interruption. The technical support is telling me that you need to be on the translation channel in order to have your audio, because there is some problem with your audio. So I think you should just switch to the English channel so that we can have the translation. Sorry for the interruption. I can hear you. I would like to know from the technical assistance if now it is working. Thank you. So I suggest we keep on with the option. I mean, you select the option you prefer, and then you keep on with that option, because it seems. I mean, if we don't have any other option, and if no one is telling us from the technical assistance which option to select, I suggest we. Lee, I think we cannot hear you, and if there is no option that you can select, I suggest we go on with any option you wish in this moment. Yes, I can hear you. Okay, perfect. So
E
Muito obrigado, Li, para trazer na nossa discussão mais um pouco de complexidade. Com certeza, esses são todos assuntos que são debatidos ao longo das próximas duas sessões de hoje, na apresentação das publicações da CPTP-Latam. Vários artigos tentam analisar e até colocar propostas regulatórias sobre como evitar viés algorítmicos, sobre como aprimorar explicabilidade e como aprimorar a transparência algorítmica, são pontos essenciais. Aí, para terminar, considerando que já estamos 15 minutos, com 15 minutos de atraso, eu queria justamente colocar uma última pergunta que foi colocada para os palestrantes, para entender qual é, na opinião de vocês, o principal desafio que temos na frente, que precisa ser enfrentado. Qual é a prioridade que seja os reguladores, os acadêmicos, as organizações de sociedade civil e setor privado deveriam ter na cabeça para entender como direcionar as discussões, as debates, a elaboração de políticas sobre inteligência artificial e transferência de dados nos próximos anos. Então, alguém quer dar uma resposta telegráfica, um tweet sobre qual deveriam ser as prioridades que deveriam orientar os nossos próximos trabalhos nos próximos anos?
Luca.
Sim, eu acho que podemos começar com o Lee e depois o Jonathan, e talvez a Laura queira também falar alguma coisa, mas vamos começar com o Lee e depois o Jonathan. Jonathan, por favor.
Gracias, Luca. Colaboraciones público-privadas con reglas claras, me parece que eso es muy importante señalarlo. Por supuesto que la cooperación internacional entre autoridades es muy importante, relevante, es necesaria. Que sean temas multidisciplinarios, la forma de abordarlo también lo es, pero las colaboraciones público-privadas con la inclusión de todos los actores son indispensables para poder avanzar de una manera más rápida. Luca, tú lo decías, gobernanza de datos personales, incluir a todos los actores en la co-construcción, que es un término que se utiliza más en esquemas de gobierno abierto, pero podría aplicar para temas de gobernanza de datos personales, de los ecosistemas digitales que sean benéficos, seguros, transparentes y que generen eso, certeza y posibilidades de avanzar de una manera más adecuada en temas de economía digital. Creo que ese sería uno de los retos más importantes hacia los siguientes años.
Excelente. Então, Laura, Daniel, vocês querem compartilhar mais alguma coisa? Laura, você quer falar assim, por favor. Excelente. Então, eu acho que essas são as melhores palavras para fechar essa nossa primeira sessão de hoje. Eu quero agradecer muitíssimo todos os palestrantes que compartilharam algumas ideias extremamente valiosas, não somente em termos de conteúdo, mas até em termos de como operacionalizar essa cooperação, esse debate multissetorial, mas também essa capacitação multissetorial que, como eu já anunciei, é um dos pontos que queremos trabalhar mais a partir do ano que vem. Agora eu queria passar a palavra ao meu amigo, o professor Nicolas Zingales, que vai moderar a próxima sessão, na qual serão apresentados os primeiros resultados, o meu grupo de resultados de pesquisa desse ano, a PDP Latam. Eu lembro que temos dois special issues, dois números especiais de duas revistas de muito alto nível, uma em inglês e uma em português e espanhol. A todas as publicações serão acessíveis em acesso aberto no site da CPDP Latam, na página sobre publicações. A maioria delas já foram colocadas lá. Então, eu passo a palavra ao meu amigo, professor Zingales. Nico, the floor is yours. Muito obrigado a todos os palestrantes da primeira sessão.
Okay, I see that they removed the translation right now, so it should be easy. Try again, Katarina, please.
I'm so sorry. I'm not sure what happened. I hear you now, actually. Can you hear me? Okay. So you presented me, right?
Yes.
Okay, I'm so sorry. Can I should I share my screen for the presentation?
Yes, please.
Okay. Let me do this. 1 second. I think that you can now see it. Yes. Okay, so hi, everybody. I will try. Okay, so I'm very happy to present today the paper, which is entitled The Thin Red Line, Refocusing Data Protection Law on Automated Decision-Making, a Global Perspective with Lessons from Case Law. And this paper, I had the pleasure to co-author with 2 of my colleagues, which are in the next slide. Doesn't work. Okay, let me try this again. Well, I cannot share the slides. I'm not sure why this is happening.
Okay, I do have a copy of those slides, so if you want, I can try and
yes,
share my screen. Okay, and then you tell me. Okay, try again for last time.
Yeah, so maybe if I skip them, yeah, let's do it that way. I know it's not the best, but let's do it that way. So I co-authored this paper with my 2 dear colleagues, Gabriela and Sebastião from the Future of Privacy Forum. And I would like to begin with telling you the aim. So the aim of this paper was to actually identify how the way that automated decision-making is being regulated under general data protection law, and the way that rights and freedoms are actually protected against the impact of automated decision-making. Before I continue, I want to to highlight that our paper is divided in 2 main parts. The first part is EU focused and focuses on the general data protection regulation, and the other part is focused on LATAM jurisdictions. So our aim is to see how ADM is being regulated under the general data protection laws, and based on the conclusions from that part, explore how some LATAM jurisdictions have been dealing with ADM practices. The scope of the paper in terms of territory jurisdictions, we have a focus on EU law, but in the second part, we have been examining LATAM jurisdictions, and more specifically, it's Brazil, Argentina, Mexico, and Colombia. In the paper, we also have China and South Africa, but in this presentation, I have focused on LATAM jurisdictions. And we'll look into the general data protection laws of these countries and the legal provisions that are relevant to automated decision-making. Coming to the methodology of the paper, we have focused on Article 22 of the GDPR, which is the article that regulates solely automated decision-making practices. And we have mainly done desktop research, meaning looking into guidelines, official documents, academic articles, but also a deep dive into enforcement actions that mainly come from data protection authorities. And talking about the relevance of this article, I will take you back to 1973, where in the US, there was a report published under the title Records, Computers, and the Rights of Citizens. And if we look into this report, we will see that one of the major concerns of the policymakers at that time was that automated personal data systems would present serious potential for harmful consequences, including infringement of basic liberties. So what we see in this report is that back then, the concern was about the decisions that would be made about individuals that would be based, these decisions, on the automation of processing of personal data. And in 1978, we see the same line of thinking also in Europe. We have the French Data Protection Act, which also has a specific, not also, but has a specific provision on automated decision-making by prohibiting automated decision-making in the context of judicial, administrative, or private decisions. Now, I have these two slides because what they say to us is that from the very beginning of the conceptualization of data protection and protection when processing of personal data happens, is the fact that there will be automation of processing operations. And it's relevant today, especially today, because of course the rule is that we have automated processing operations, let alone the whole debate on artificial intelligence and what this entails. As I told you, the first part is focused on EU law, and I would like to tell you that this is based on a report that was published by my two colleagues back in May, which takes a really deep dive into enforcement actions with regard to automated decision-making, and I encourage you to take a look at it. Now I will go into the presentation, into the core, like the content of my of the article. I would really love to try again the slideshow because I have some animations which I will try it. If it doesn't work, I will give up on it. Okay, great, it works. So so the first part is about EU and the GDPR. One thing we need to understand is that the General Data Protection Regulation does not regulate a specific technology, but regulates an activity, meaning the processing of personal data. So it's a technology neutral law that cares to ensure fairness when processing of personal data takes place, no matter the means and the technology used. In recital 4 of the GDPR, it says that the processing of personal data should be designed to serve mankind. And Article 1.2 of the GDPR mentions that the whole legal framework aims to protect all rights and freedoms that might have an impact due to the processing of personal data. So it does not only protect data protection or privacy, but all rights and freedoms. One thing that we need to have in mind when reading this paper, but in general as well, is that the GDPR regulates 2 types of automated decision-making. So the first type is the decisions that are based solely on automated processing. The second type are the decisions that are based on automated processing, so not solely automated. Looking at the solely automated decision, of course, when there is processing of personal data, the whole of the GDPR applies. It is especially relevant, the transparency obligations, and the transparency, the right of individuals to know that there exists such processing, as well as the right of individuals to get meaningful information about the logic involved, the significance, and the envisaged consequences. So this is particularly relevant into this ADM context. And non-solely automated decision-making, we have the same network of principles and rights and obligations that protect individuals. So all the GDPR provisions, and particularly the right to know the existence and the logic, etc. The extra layer of protection that is given to solely automated decision-making processes is Article 22, that sets the right of individuals not to be subject to this specific type of automated decision-making. Let's dig a bit deeper in Article 22. So solely automated decision making, when there is a decision that is based solely on automated processing, and this decision has legal or similarly significant effects for individuals. In this case, the GDPR says that this is actually prohibited. Of course, there are exceptions. So if this type of processing is necessary for the individual to enter into a contract with the controller, if there is a legal obligation by which the data controller is to which the data controller abides to, or when we have the explicit consent of individuals, then it is possible to have solely automated decision making. However, the law says that in that case, there need to be safeguards. The individual should have the right to obtain human intervention. They have the right to express their point of view. And of course, they have the right to contest and challenge the decision. And I would like to remind you that on top of this, we also have the general obligations and rights. So the right to be informed that the automated decision-making takes place, the right to receive meaningful explanation about the logic involved, and the right to receive explanations on the significance and the envisaged consequences for the data subject. So there is this network of protection, and I would like to go and move to the enforcement actions that we have looked into. There are two major categories that the data protection authorities have paid attention to. So the first condition to qualify an automated decision-making as the one required under Article 22, which is prohibited, is that it's solely based on automated processing. The first question that we need to ask is whether there is human involvement at all. So if there is no human involvement, this is a clear case of solely automated decision-making, which is, as a rule, prohibited under Article 22. If there is human involvement, then what needs to be understood is whether this human involvement is meaningful. And this is the only case where if we have meaningful human involvement, then the automated processing is not solely based on this means. The data protection authorities that have dealt with this question have established some criteria, and we have grouped them under three groups: the timing, the content, and the underlying arrangements. So in terms of timing, in order to answer whether we have a meaningful human involvement in the decision-making process, data protection authorities have said, well, we need to look into the final decision and whether a human has any sort of contribution before the final decision is made. In terms of content, authorities have said that mere token gestures are not enough. So basically, the human needs to consider factors additionally to the recommendations by the automated system when they make a final informed and conscious decision. The third group is the underlying arrangements. So data protection authorities have said, well, to have a meaningful human involvement, there needs to be like an indication of this meaningful involvement is the fact that there are guidelines or protocols or effective training of the staff that helps the staff understand in what way should they take into account the recommendations, how should they tackle it, and where their involvement lies. Also, of course, another criterion is whether the human has an appropriate authority and capability to change the decision. So this is one group of cases the data protection authorities have dealt with. The other part deals with legal or similarly significant effects. To assess that, we actually need to assess the seriousness of the effects of the decision on any aspect of an individual's life. To assess whether we have a legal effect is kind of easy given that, so we have a list of examples in guidelines, such as when the decision leads to a cancellation of a contract or when the decision leads to a denial of a social benefit. When it comes to assessing whether the effect is similarly to the legal effect significant, we do not have a list of criteria. So the data protection authorities, there are no guidelines on that. We just have some interpretation of this concept by the authorities. And they say that for an effect to be significant, it should be impactful, long-term, or lasting. And maybe I could, or maybe let's leave it in case there is a question or comment afterwards. I'm not sure how I'm doing with the timing. So until now, we have seen data protection authorities dealing with Article 22, meaning solely automated decision-making, which we said has a higher level of protection under the GDPR. What happens if an automated decision-making process does not meet the high thresholds of Article 22? The question is, does it go unregulated? And the answer is no. We still have data protection principles, lawful grounds, rights and obligations that protect individuals against any type of ADM. And data protection authorities have also dealt with this type of automated decision-making processes, deciding that they are unlawful on the basis of the breach of, for example, a transparency or fairness principle, or because there is lack of lawful ground. All of what I'm saying, we have examples of cases and enforcement actions in the paper. So there are more examples there. A basic conclusion is that the GDPR covers ADM processes and systems in a comprehensive manner. So it creates a protective net for individuals even when the specific ADM provision cannot be invoked. Having this conclusion in mind, in the second part of the paper, we wanted to see how some LATAM jurisdictions deal with ADM and how individuals are protected. So the methodology is again desktop research, mainly looking, so also because of language issues, we mainly looked into the laws and used whatever translation, official or not, is out there. But also we thankfully have some colleagues that speak, like, for example, Spanish and Portuguese. With regard to the scope, I already mentioned the jurisdictions that we have dealt with. We looked into specific concepts that we considered as very relevant to the protection against automated decision-making. The first one is processing, operation, and personal data, given that both definitions, if they're wide enough, that means that individuals can fall under the protective scope of the general data protection laws. The principle of transparency is a core one, not only because it gives control to individuals, but also because it's an important precondition for other rights to materialize. For example, the right to contest a decision. You need, as an individual, to know that ADM is taking place in order to challenge a decision. The principle of fairness is core to the debate around ADM and AI, of course, and we looked into whether there are specific ADM provisions. The first jurisdiction is Brazil. The General Data Protection Law, the LGPD, entered into force in 2020. Looking into the definitions of processing, operation, and personal data, they both have a very broad scope. There is a principle of transparency along with a principle of free access. While there is no explicit principle of fairness, there is a principle of good faith and, interestingly enough, a non-discrimination principle. This principle tackles not only the discriminatory aspects of processing, but also extends to the unlawful and abusive purposes of processing. Article 20 of the LGPD has a specific ADM provision, which is not framed as a prohibition, as we saw in the GDPR. There is a right of the individual to request a review of the decision when we have solely automated decision-making that affects the interests of the data subject. There is also a right to request information by the controller on the criteria and procedures used for the automated decision. However, the controller may refuse such access request on the basis of business and industrial secrets. There is no right to object to the processing, contest the decision, or to be heard. Looking at Mexico, there are two laws. So there is a data protection law that applies to private sectors and is supplemented by the regulation, and a data protection law that applies to public sector. Looking at the private sector data protection law, we have a very broad scope in the definitions of processing, operation, and personal data. A principle of information when it comes to every aspect of the processing. There is a principle of loyalty, meaning that personal data should not be processed and obtained through fraudulent means, and the processing should meet the reasonable expectations of privacy, which is core to the principle of fairness. The regulation has an article in Article 112, which is specific to ADM. It is not framed as a prohibition. There is an obligation to inform the data subject that ADM is taking place. There is a right of access, and there is a right to rectification if the data is inaccurate or incomplete. Only in the case where the data is inaccurate or incomplete has the individual the right to request the reconsideration of the decision. And the data protection law in the public sector has, in that law, there is the right to oppose the processing or to request that the processing ceases. And the wording is more in line with the GDPR wording. In Argentina, we have the PDPA, which is currently under review. There is a broad scope of both definitions of processing, operation, and personal data. There is no principle of transparency, but there is a principle of information, and no principle of fairness, but a principle of data quality. And again, we see that the collection of data should not be done by fraudulent or unfair means. The ADM provision is limited only to judicial or administrative acts, leaving outside ADM in the context of private sector. But the resolution number 4 of 2019 says that we need to pay attention to the risks raised by the ADM, and a right to request an explanation of the logic applied should be in place. And the last jurisdiction is Colombia, and its general data protection law from 2012. Again, a wide scope in the definitions of processing, operation, and personal data. There is a principle of transparency, no principle of fairness. However, in the regulation decree, there is this requirement of no collection of data by deceptive or fraudulent means. And there is no ADM provision, and this is the only jurisdiction among these four where we do not have an ADM provision. And with this, I would like to conclude and just say thank you, and just say as a conclusion that our aim and our main basic conclusion was to say that even if there is no specific automated decision-making provision in a law, if we have processing definitions of processing, operation, and personal data wide enough, then so as individuals can fall under the protective scope of the general data protection law, then we're actually protected, individuals are protected by the rest of the principles, legal grounds, rights, and obligations that are in the law, even if there is no specific ADM provision. Thank you very much. That would be it.
Thank you very much, Katerina. Very interesting presentation, providing a very, very comprehensive overview of the principles and provisions that are available in different jurisdictions. So I'm leaving some time here for questions. I don't see anyone coming from the floor. But I would, while we are waiting, I would abuse of my moderator role to ask a couple of questions to you. So in your conclusions also, you emphasize that maybe even if there is no specific provision on automated decision-making in the law, individuals can be protected by the principles of data protection. And this, I think it's very important. At the same time, we are aware of jurisdictions where there's a lot of litigation, and especially when there are broad open-ended principles, this can be applied in ways that are not necessarily in line with the spirit of the law. So I wonder if what is your take on that? Because you say that yes, you can be protected by this principle, but do you actually suggest that this would be sufficient and then maybe complemented by some guidelines, or it would be preferable for a data protection law, for example, in the Latin American region, to have a specific provision dealing with automated decision making, for example, bringing the case of Colombia, or do you think it's sufficient what we have? A second important point of the presentation is when you differentiate between places or jurisdictions where there is a default position that prohibits automated decision making unless certain conditions are met, and others where instead there is no prohibition, but individuals have a right to invoke certain things, certain protections when this automated decision making applies. So here again, do you think it makes a substantial difference? Is that your suggestion that there should be a sort of a prohibition approach, or is it better to instead leave it to the individuals to invoke it in the particular case that the protection must apply? A third point, which I think is relevant, is you discussed that, for example, in Mexico, there's a distinction between the public and the private context. So also in that regard, would there be a sense that it is fair to have different principles applied in the public and private context? So here it might be relevant to mention that, for example, in the GDPR, one particular type of traditional public activity is investigation and repression of crimes. So for that, we have a whole specific legislation in the European Union. Now, in certain countries, there is no such distinction. The general law would apply. Maybe there are some exceptions. But here also, I wonder, what's the take of your paper? Should the regulation on automated decision-making encompass both areas, or should there be some differentiation between the two? And finally, like as a footnote, you mentioned the principle of good faith that, for example, applies in the Brazilian framework. Now, in the Brazilian framework is different from the principle of non-discrimination. So I wonder if there is a sense in which, in this research that you have done, fairness, good faith implies something more than non-discrimination. So this is something that you can share amongst more countries than just Brazil, for example, with regard to informational due process. So I think that there was a lot of questions. I need to answer them all, but I would be very pleased if you can. I see also there's another question right now coming in. So it says, from an anonymous attendee, GDPR does not provide explicitly the possibility for auditing algorithms, particularly for discriminatory issues. In the Brazilian data protection law, there is an express provision for that. Do you think this is an advance of the Brazilian legislation in comparison with the European legislation? And with that, I leave you about 5 minutes to answer all that.
I hope I remember the points. So I will start by fairness, and please, I might ask you to repeat something because I might forget. So I will start by your last point on fairness, which is one of the most difficult principles we have because nobody has ever managed to capture it. I will let you know what we have. So I have the paper in front of me because I want to read this part. So with regard to the principle of fairness, we say in the context of ADM, fairness of specific processing operations could be understood as a decision which is non-discriminatory, unbiased, non-manipulative, and that in general does not exploit a significant imbalance between the controller and the subject in particular contexts. And this is Of course, we refer in the paper from Professor Malgeri, a paper that he wrote. So fairness is way more than discrimination. It's not only discrimination, it's more than that. It's part of it is like the imbalance of power between controller and processor. It's the expectations that an individual has from the processing that takes place. Now, the concept of good faith in the Brazilian LGPD, so from the research we did, we didn't find any particular guidelines on how this has been understood. Let me check in my presentation. I might have it or might not.
Actually, we have a live interaction from another speaker, Walter Brito, who is from Brazil and maybe wants to chime in on this.
That would be awesome.
Hi. Yeah, I think that's a very interesting subject, and what comes to mind is the theory developed by Professor Bruno Bioeni in his one of his works on the LGPD, in which he connects good faith, the Brazilian concept of good faith, to contextual privacy. So it is very much something that regards the contextual elements of the data processing relationship and measures the balance of power between people and the legitimate expectations of each party in relation to the other. So I think it's a close concept to fairness, yes.
Yeah, this is why we actually captured it, because even if there, and this, we encountered it in more jurisdictions, even if there is no specific principle of fairness, there can be aspects that could be captured under the concept of fairness as we understand it. And by we, I mean we, like the authors, and also because we have a European background, the way it has been dealt with in Europe until now. Great, now I have forgotten all the rest.
We have like 3 or 4 minutes, three minutes in theory, but so the other question were more about like, do you think that this principle-based approach should differentiate between different types of context, like for example, public and private, or also do you think that there should be maybe some preference for a default position that is a prohibition against the automated decision-making, which has certain effects maybe, or instead, something that should be activated by the data subject?
Yeah, so, okay, so the basic difference between having a specific automated decision-making provision of a prohibitive nature. So you can have either a prohibition or a right of individuals. A prohibition is under the GDPR. This is what the EDPS and the EDPB, I think both have said, that it is a prohibition. The problem, if it's a right, as is the case of the LATAM jurisdictions we looked into, is that actually the data subject herself needs to activate and do the whole process. So the burden of proof is on the data subject to, first of all, realize that this is happening, and secondly, to go into a whole list of actions in order to get the protection. So to request information, while if it's a prohibition, the data controller needs to actually prove that it's necessary, in the case, for example, of contracts, to prove that explicit consent is valid because they have provided, so the data controller has provided to the individual all necessary information, as well as the logic involved and all the parameters of the algorithms. So if you ask me, having a prohibition instead of a right is better because it puts less burden on the shoulders of individuals. And I now remembered the question with the audit that is in the LGPD, right?
Yes.
So I see, I'm trying to open the translation here. So let me check it. The controller, so as we said, the controller can deny the provision of information having regard to the business and industrial secrets. And then it says, in the event of a failure to offer the information set forth in paragraph 1, so because of the on the ground of business and industrial secrets, the supervisory authority may conduct an audit to verify discriminatory aspects. So this audit, I understand from the translation, and please correct me if I understand it wrongly, that it's limited to the case where, first of all, the data subject has requested. Secondly, the data controller has denied due to business and industrial secrets. To my understanding, it's quite limited. Of course, auditing is always welcome, but the way it's framed, I understand it as more limited.
Yes, so I may chime in on this one. The original text of the LGPD did not have very specific detailed provisions on what the authority would do, because at that time the authority was not yet activated, let's say, when the law was passed. So they thought it was important to include this provision here, but actually the new text of the law supersedes that. So the auditing is possible beyond those specific circumstances. Right now, I think this has been settled. Yes, the other point that is left out is whether you see any meaningful difference between public and private. So should there be the same kind of provision applying to both? Your brief take on that.
Well, yeah, my brief take is that, well, first of all, I think that having a general law that is more principle-based is important, because that means it can deal with whatever comes in whichever context. So I think that this is important. And of course, this afterwards is a matter of interpretation and enforcement. And with this article, one of our aims is actually to show that enforcement is important, because it allows to interpret wide notions and concepts that are not understandable or clear-cut from the very beginning. The difference between public and private, of course, there are differences that need to be tackled with. And this is why there are specific laws which are specific to the general laws that deal with, for example, in the EU, law enforcement and this type of activities. I do see a value of differentiating that. However, I do also agree that there should be a general law with principles and basic rights that could fit in every context. And then the particularities of each context should be dealt with separately or by case law.
Excellent. Thank you very much. That answers the question. And I think it was an interesting discussion. What also you emphasized the importance of understanding fairness in a broad sense. I think is particularly important. Already our next speaker has mentioned, some of the doctrine that is being developed around that. But I think there needs to be more discussion in Brazil, for example, on how this concept can be interpreted. In the European framework, I think an article that provides quite some good reference is by Damian Clifford and Jeff Auslos on the principle of fairness, and they distinguish between a procedural and a substantive aspect of this. And I think maybe here we are being more focused on the procedural side, and there could be some more advancements being made in this discussion on what it means from a substantive perspective. But this will be maybe a theme for another debate, and we hope to see you again participating in our call for papers in the 2023 CPDP LATAM, and I think this will be a very relevant topic. So thank you very much, Catarina. I know you have to run. Thank you for being with us. And I'm
so sorry. Yeah, this is what I want to say to the rest of the speakers. I will have to leave. I'm so sorry. I really have to, because Now it's like 6 p.m. in Greece, so I have a course to attend. Thank you so much for having me, and yeah, good luck with the rest.
And thanks also to Gabriela and Sebastian for participating in this effort. All right, so now we'll move on to the second speaker, who has already not introduced, but who has already spoken. His name is Walter Brito. He is a researcher at the CyberBricks project at CTS, so Center for Technology and Society here at FGV. He has a law degree from FGV and a master in collective health from the State University of Rio de Janeiro, and he's also a PhD candidate at the Federal University of Rio de Janeiro. So his paper is co-authored with Luca Belli and Yasmin Cursi, and it's AI regulation in Brazil, advancement, flows, and need to learn from the data protection experience. So with that, Walter, you have the floor.
All right, thank you. Let me share my screen here. Okay, do you see it?
Not yet.
Yep. No, not yet.
A little bit slow. Try again. Maybe restart the sharing.
Not yet. Okay.
Nothing.
Hi. Sorry, my Zoom crashed for some reason. I'll try and close some of the other applications I have opened here. Maybe it's a problem with the RAM.
If you want to send me the slides, I can also share them for you.
Okay, let me just try one more time. Okay.
No.
Walter, if you want, you can send it to me.
Thank you, Yasmin. Yes, maybe Walter, you can send the slides to one of us. And then
Yeah, I'll send you. I'll send it to. Here.
Well, the good thing is that we have some leeway, some flexibility, because there is a 1 hour lunch break. And I think that if, considering we started quite late, we can also eat a little bit into the lunchtime, but hopefully not by much.
Yeah, I sent it to you and to Yasmin on Signal.
Perfect.
I'm opening it.
All
Just
right.
a minute.
Yeah, my Zoom is completely broken. I don't even see the
Yes, we are not seeing your
video feed from anyone.
Yes. We are not seeing you too.
Yeah, weird.
Sorry, my computer is pretty low here at the office. Just a minute.
I can do it without the presentation as
Oh, it's
well.
okay.
It might be.
Is it working?
Oh,
Are
yeah,
you
yeah.
seeing
Yeah.
my screen? Okay.
Okay.
Sorry.
Please go ahead.
Okay, so I planned for around 15 minutes, so I'm gonna try and be quick so we can have a little bit of a discussion. I'll also have to leave early because I also have classes right after this, but I'll try to stay for a bit right after. So our paper is AI regulation in Brazil, advancements, flows, and need to learn from the data protection experience. Next slide, please. And okay, and we had a preview, spoiler of the whole presentation. And this is a quick outline of the presentation, and also that's the structure of the article. So I'm going to introduce the topic, then discuss some emerging approaches to regulation and how they relate to the existing framework in Brazil, the General Data Protection Law, and then present our critical analysis of the subject. Next slide, please. So I think it's needless to say how impactful artificial intelligence applications can be, both in disruptive, innovative ways and also in its harmful consequences. The Brazilian framework has to deal with the challenge of regulating future tech today, which means dealing with the sometimes unknown consequences and unmeasurable risks and also unpredictable applications of technology that is still in its development phase, although we do know much more today than we did a few years ago about the risks of AI. But anyway, and in this effort, the Brazilian framework is composed currently of the EBIA, which is the Brazilian artificial intelligence strategy, and the AI bill, which is a proposed law, which was approved in Congress and it's currently being discussed in the Senate. And also the main reference here would be the personal data protection law, but there are also other applicable laws, but the most encompassing one is the LGPD, the personal data protection law. In terms of methods, our approach was a documentary review. We looked at archives of the public consultation on the strategy, also documents regarding its governance committee and the proposed bills and the current legal text. Next slide, please. Let's just jump into these emerging approaches. I'm not going to take long here. In the article, we go into a little bit more detail on the foreign approaches to regulating AI, but I think they're a good, useful reference for where we could be aiming with our AI framework here in Brazil. And then a question that I introduced right there on that topic is are we doing a postponement of actual regulation with our approach here due to some factors that I'm going to discuss later on. So the first topic I want to approach here is the Brazilian artificial intelligence strategy, because it was the first, let's say, the first concerted effort by the federal government to organize AI in the country, so AI in terms of strategy, objectives, and also regulation. This artificial intelligence strategy was created through a public consultation process, an online consultation. In April 2021, it was published, and it added 73 strategic actions to the 9 axes that were already presented during the consultation process. And although it did have 73 strategic actions, it was very much criticized for not being actionable and concrete enough for a strategic plan. So it's lacking in terms of timelines, specification of resources, attribution of responsibilities, success metrics, etc. And in some cases, these were actual contributions to the public consultation process, which weren't incorporated into the final document. So it was, in this sense, lacking in the necessary applicability, immediate applicability, to actually trace a plan to reaching the objectives of the strategy. Next slide, please. Right after the strategy was published, a governance committee was created. This governance committee, it was mentioned in passing in the decree that created the strategy. But then right after it was the strategy was published, it was created. Its bylaws mention representatives from 3 stakeholder groups presented here. One is the Ministry of Science, Technology and Innovation, the other a network of AI innovation, which involves companies and the ministry. And the third one is a very big category of invited institutions. And these invited institutions are not specified in the bylaws. The criteria for choosing these institutions, for inviting them, is not specified. And there isn't a clear path to becoming an invited institution or to being invited. So in that way, there's a fair amount of opacity in terms of who gets access to this governance committee. And also in its inner structure, let's say, the working groups work in a similar manner. It's invited institutions, and we can't really know why they were invited and how one would be able to be invited to a working group. So, and this brings us to a few concerns that I'll present later on, but next slide, please. So looking at the governance committee, we built a classification of the actors involved in the composition of the governance committee. And one important finding is that throughout the meetings, a significant majority of government and private sector association representatives in relation to academia and civil society was observed. Next slide, please. And this is an issue for us under our critical analysis, because broad participation of academia and nonprofit civil society should have been considered in developing such a body and in its decision-making procedures due to the characteristics of the subject being discussed. Next slide, please. And another important finding was that the National Data Protection Authority only appeared at the 4th meeting of the governance committee. And it was actually only mentioned in the 2021 results report once or twice, if I'm not mistaken, in the discussions of one of the working groups. Next slide, please. So that's actually very weird to see, because Brazil has a deeply rooted multi-stakeholder governance tradition. If we look at, for example, the Internet Steering Committee. Next slide, please. So quickly moving on here to the artificial intelligence bill. As I said, it has been approved in the Chamber of Deputies and is now in the Federal Senate. And in the Federal Senate, it is currently being discussed by an expert commission, which was formed to propose a new text for the bill, or reforms to the bill, due to its original text being very much criticized, not only for having been for having had a very short discussion period in the chamber, but also due to some substantive issues, such as adopting a minimalistic approach. If we compare it to, for example, the AI proposed bill, it's got only 10 articles dealing with the issues, the Brazilian bill. Also, some significant gaps, and especially the proposed subjective liability framework, which was particularly criticized by many observers. But Professor Laura Schertel gave a more detailed analysis of this discussion process earlier today. So I think I invite everyone to watch the recordings afterwards because it was very informative. And finally, moving on here to the relation of this AI bill to the current data protection regime we have in Brazil. The principles are the principles of the general data protection law can be found in the AI bill, however, in a mitigated fashion. So, for example, non-discrimination in LGPD is a general prohibition, whereas in the AI bill, it is a mitigated duty. It is not a general prohibition as in the legal text of the LGPD. Transparency in the LGPD is a general duty to inform and disclose, whereas in the AI bill, it's conditioned to certain situations. The revision of automated decisions as well. It's in the LGPD, it relates to situations where the data subject's interests are at stake, whereas in the AI bill, it's related to considerable risk to fundamental rights, which is a very different approach to the one we find in the LGPD. And also, finally, there's a matter of whether the authority would become a personal data controller and an AI controller, whether that would be feasible and desirable. And that's one answer that the AI bill doesn't give. Okay, I'm moving on quickly to the conclusion. Next slide, please. So our final points here. We observed an issue with transparency and debate and accountability in the creation of this AI framework in Brazil. So the policymaking efforts, they lacked sufficient transparency, as we saw, especially in the composition of the governance committee of the ABIA and the quick discussion of the AI bill. It is an evolving scenario, so Brazil is a little bit behind in the regulation of AI. So there's the issue of hitting a moving target and interests becoming more and more rooted as implementation of AI becomes more and more common. And there's a need to harmonize these approaches, the AI framework, with the existing legislation. And what we see as a path forward is deepening the multi-stakeholder structure of discussions in order to give a more holistic comprehension of the issue at hand. I think I managed to not go over the 15 minutes by much, and thank you very much.
Yes, thank you very much, Walter. Just 1 minute, but it's perfect. Unfortunately, I'm affected by the same problem that you are affected by, so my video is not coming out. I will have to disconnect and reconnect, but first let us have some discussion over this paper. So let me see if we have some questions from the floor. I don't see them right now. Maybe they will come in. One question that I would have is, you have an interesting approach in the paper as you try to categorize the contributions that are made in the public consultation, not using the traditional stakeholder categories, but your suggestion is to focus more on the substance of the interests that are represented. So I wonder if you can elaborate a little bit on this and explain to everybody, what are your recommendations in that regard. A second aspect that I think is interesting is to be a little bit more specific on the way in which data protection law can teach the way forward to the AI regulation. So, I understand that some of this has to do with the burden of proof that needs to be overcome by data subject, which is facilitated in data protection law and maybe not so much under this new bill. But are there other things? I think you mentioned transparency, but if you could be more specific on your recommendation, I think that would be to the benefit of the audience. Then I think also with regard to transparency, transparency has been measured for two different reasons. One is the transparency over automated decisions, and the other one is transparency over the process of how the regulation is developed. So when you use data protection as a good example, are you referring to one, or the other? Are you referring to the substantive, or let's say the process transparency? I think on both there are some significant positive lessons that can be learned, but I wonder maybe you can elaborate a little bit about this. And right now I don't see any other questions, so you can answer any of these.
Okay. And also, I think Yasmin is connected, so if you want to jump in, just feel free.
Sure.
So on the matter of the substance of the interests involved, that was what happens is if you draw a classification based on, for example, the legal structure of the actors involved, you end up with an skewed categorization, because private sector associations and NGOs might be structured as private associations, which is the same legal form. However, they have very different agendas and mandates, let's say. So on the one hand, you have a rights-based association based on taking action regarding fundamental rights of individuals, and on the other hand, you have an industry association, which is naturally going to care about other issues. Not to say they don't care about fundamental rights, but just the mandate is different. So we try to build a classification that took into consideration these nuances, because at a first look, the composition of the governance committee seemed disproportionate in terms of the participation of these private sector associations in relation to academia and to non-private sector associations, and I think that's a particularly important matter to consider, and this I think connects to the idea of process or substance in the not the transparency but the accountability, let's say, or the decision-making process, because it matters, who's at the table matters in discussing these issues, especially when dealing with artificial intelligence and applications which might be affected by algorithmic bias and the kinds of biases that by definition they are not they might not be perceived by very homogeneous compositions. Having a truly multi-stakeholder approach can really benefit the substance of the final decisions as well as the process. So I think that's I don't know if Yasmin wants to jump in, but I think that's the first question. Okay.
Nothing to add.
You can go ahead. I think she agrees with that.
Okay. And in terms of the lessons that we may draw from the data protection legislation to regulating AI, I think, yeah, the matter of the burden of proof that you mentioned is very I think it's a very important. It was the most ardently criticized topic of the AI bill, I think, and for a very legitimate reason. We're dealing with relations where the disparity of information and power between the data subject and the data controller are very, very significant. And this both in data protection, data processing relations, which don't involve AI applications, but also in AI applications, and even more so in AI applications, because we're dealing with a black box, a system which works on heuristics and can't always be explained. So I think in that sense, it's important to prioritize the capacity of the data subject to cross that, to overcome that disparity. And the way to do that is by enacting strong protection in the sense that the LGPD does. For example, with the very the encompassing principles, the way they are written, and that the AI bill didn't reach the same level of protection due to its mitigation of the application of those principles. So I think that's one important lesson to learn.
Yeah, I think so. My question was, yes, indeed, this is a very relevant point. Query whether there are other aspects of data protection law that could be used in the regulation of AI context that you think are relevant to mention, so, beyond the burden of proof.
Okay, yeah, I think, let's see. There is, I think the issue of explainability and the duty to the right to revision and the accessory right to information on the automated processing of personal data is something that should inform the approach taken in the AI bill, even though there was a mitigation of this provision in the LGPD due to the presidential veto of parts of it. It is still a significant right, and its interpretation could lead to a stronger application of this right, especially in the issue of access to sufficient information on this automated processing. And I think that it's not resolved, but it charts a path for the AI bill, for example. So that's something that could be more detailed and specified in terms of actual the nitty-gritty of how this right could be implemented, because it's a very important, significant issue, and with deep ramifications in how these applications are put into practice.
Perfect. Yes. So I think that maybe I can redirect one question to Yasmin with regard to the issue of transparency. So it was mentioned. I think that inevitably we will have some things that are going to be not addressed in detail by the regulation, but are going to be left up for either the authority or the codes of conduct of the industry to be developed more in detail. So in this regard, I think that we have seen from a process perspective, the data protection legislation being developed in a very participatory manner, much in line with the traditions of the internet law, here in Brazil. And the ANPD, the Data Protection Authority, has published a plan of regulation for the coming 2 years, and they open consultation on basically any important issue on which they're going to rule. So this is probably something that the data protection experience can teach also to AI regulation. But more generally, I wonder if you have any specific suggestion that you want to make to the commission of jurists that is now elaborating a project for the regulation of artificial intelligence with regard to this. So how the regulation should be implemented in more detail. What is the level of transparency and participation that you would like to see in there? I know that Yasmin is working on that topic, so please, Yasmin, feel free to respond.
It's a difficult topic to be addressed prior in the legislation development. I think, as you said, most of the proper regulation regarding transparency, they will come through normatives to regulate from the regulators, regulation bodies specified for such for developing such norms. I think that the main issue with the AI bill was that it was put on this on a fast track procedure before the commission of legal experts to be developed, to be created, and etc. I think that now probably we will have a totally different version of the draft bill, and I'm really excited to read it once it's published. But I think that it's important to have in mind what kind of transparency measures the bill can have once it's ready. Proper capacities for people, for the users of AI systems to understand what is the data that is being used, how their data is managed within the systems. I think the AI bill can provide, like making even remissing the personal data protection bill, for example, even quoting it. I think this kind of measure can be already stated in the AI bill. And I think that a proper agency also to handle problems and issues with data, with users' data within the ANPD, the National Data Protection Authority, would be also a good step for dealing with these issues. I think this too is totally possible within our already data protection framework.
Yes, thank you. And just a quick reflection, I think that what we are learned in the data protection experience with regard to, in particular, automated decision making, is that there is a need for transparency, not only about the specific decision that is taken, but also more generally, about, for example, the system, what they call system functionality. So how an automated decision-making system works, and even the fact that these decisions are being taken. So as Katarina was also mentioning before, some of these protections are very difficult to apply if the people who need to invoke them are not even informed that this is happening, and what are the general characteristics of those systems. So I think that a good way to think about transparency in this context is to divide between wholesale transparency and retail transparency, which I know is a terminology that is used here in Brazil in the transparency discussions. So, for example, about how the controllers can make sure that the system is not affected by excessive biases, and that these are kept within reasonable limits, and what is done to ensure that there is an ability to contest, etc., and then look at the specific decisions. But this was just my reflection. Sorry for abusing my role as moderator. I think that right now we have reached our time with regard to this paper. Again, I invite everybody to read it. It will be available on the open access on the website of CPDP Latam, and it will be published very soon in the Computer Law and Security Review journal. So with that, I thank you both for your intervention. Now let's move on to the next speaker. Here we have Pablo Trigo Kramsak. Apologize if I'm not pronouncing it correctly. The title of the paper is "Can Legitimate Interest Be an Appropriate Lawful Basis for Processing Artificial Intelligence Training Datasets?" So a very specific contribution. I see that you have already shared your slides. Let me just mention briefly, Pablo is a PhD researcher within the Law, Science and Technology and Society Research Group at Free University of Brussels, funded by the Becas Chile Scholarship in Digital Transformation and Technological Revolution. He's also a researcher at the Center for Information Technology Law Studies at the Faculty of Law at the University of Chile. So with that short introduction, I leave you the floor, Pablo.
Thank you, Nicola. Can you hear me? Yes?
Yes.
Okay, perfect. Can you see the slides?
Yes, they're not in presentation mode, so
okay.
Try to put. Yes.
Because when I project in presentation mode, I cannot see the slides. I don't know if it's a problem.
No, then go back to the other configuration. No problem.
Okay. Okay. Thank you. Well, thank you. Thank you very much. Well, this paper is part of my PhD research that I'm completing in the Vrije Universiteit Brussels, and it's about general terms about the problems regarding with having appropriate training, validation, and testing data sets for developing AI, trustworthy AI. And in some way, this paper trying to reflect the first approach, my first idea, notions regarding with this this problem, the challenges involved in regulatory aspects that are involved in this, especially regarding with the data protection law. Well, I would say that over the past 2 decades, the confluence of different technologies has made possible the expansion of AI models that, in a broad sense, can mimic human abilities, including decision making. And we can see, for example, in financial markets regarding credit scoring in consumer loans, in insurance, predictive behavioral analytics, human resource management, recruitment using AI, in healthcare, regarding medical diagnosis and treatment with AI, education, school admissions using AI, and in criminal law and predictive justice for all decisions based on statistics and risk scores. AI is a concept that in its comprehensive meaning refers to the analysis of data to model some aspects of the world. Inferences from these models are then used to predict and anticipate possible future events. And this is linked with linked to the increased flow of information and the widespread use of big data analytics to diagnose problems and predict outcomes. And in this context, AI systems have the capacity to compile, analyze, and process vast amount of data from multiple sources to achieve reliable outputs and predictions. Precision and effectiveness of AI models are highly dependent on the availability of relevant and representative trained data. AI systems tested and validated on poor quality datasets can produce inaccurate, erroneous outcomes, actions, behaviors, or decisions. And of course, AI generates new opportunities, but it also poses challenges and risks. Regarding the risks, there are concerns over the possibility that AI systems recommend or adopt fully automated decisions against against the interests and rights of individuals. The outputs generated by AI technologies have an increasingly growing effect on individuals, which may affect their fundamental rights, including the rights of freedom of expression, human dignity, non-discrimination, private life, personal data protection, and political freedoms, for example. Well, there are different levels of depth or complexity of AI. Among its most advanced modalities, machine learning systems stand out. They are linked to the design, programming, and development of autonomous learning computer applications, which employ diverse methods capable of analyzing behaviors and recognizing patterns from experience gained over time. At all steps of machine learning design and development, including gathering and measuring relevant data for supervised and or unsupervised learning, training of a set of data-dependent algorithms, and testing, validation of an algorithmic model, different types of personal data processing operations can take place. And in that sense, for building more reliable and trustworthy AI systems, minimizing the potential risk of bias, which may result in arbitrary discrimination, unfair decisions, denial of services, a better data curation is required. And the importance of data curation for AI development has been highlighted by a wide range of public policy instruments and guidelines issued by different governments and public regulatory and supervisory agencies. And for example, the Norwegian Data Protection Authority points out that when training an AI model, the quality of the training data, as well as the features used, can in many instances be substantially more important than the quantity, emphasizing the importance of the selection of training data. The ICO, the UK Information Commissioner's Office, highlights the importance of data collection and data fairness for responsible AI design and implementation. Outside Europe, in Asia, the South Korean Personal Information Protection Commission points out as a basic direction of AI-related personal information processing the importance of collecting personal information in a legitimate way. Also, the DPA, the Personal Data Protection Commission of Singapore, that issued a mobile AI governance framework, states that AI risk management and internal control comprise making reasonable efforts to ensure that the dataset used for AI model training are adequate for the intent proposed and to assess and manage the risk of inaccuracy or bias. Regarding Europe, the European Data Protection Board, in its guidelines on data protection by design and by default, refers to the collection of AI training data from data sources with correct and up-to-date information as an example of how to comply with data protection by design and by default requirements. Finally, the EU Artificial Intelligence Act proposal refers extensively in Article 10 to data governance in AI context, focusing in high-risk AI systems, which make use of techniques involving the training of models with data. That is Artificial Intelligence Act proposal stipulates or pays close attention to the choice and curation of training data and to various types of testing that this kind of developments involve, pointing out that, for example, training, validation, and testing data sets shall be subject to appropriate data governance and management practices, including data collection. All these data sets shall be relevant, representative, free of errors, and complete. We can see that AI data creation involves many difficulties. From a practical point of view, creating new databases for AI and machine learning development processes has significant cost. And in this regard, it is possible to identify a limited number of benchmark databases, use it and reuse it in AI and machine learning research. It is also important to keep in mind some intellectual property issues in regard with these data sets. we need to consider also multiple regulatory challenges, especially visible in the personal data protection field. Data protection laws and regulations apply when personal data is involved. And in this context, the first challenge is that the line between what is personal and what is not personal data has been substantially blurred by the correlations and inferences that can be made from aggregation of datasets. Information that once seemed to be non-personal now has the potential to be personal data. And data users and regulators alike are faced with the difficult task of determining which data should be subject to this regulation. Okay. In that sense, it can be asserted that AI is in tension with many data protection principles: collection limitation, proposed specification, and use limitation, data minimization, transparency. All these principles are always in tension when AI development. Another key issue for big data analytics and AI is whether the identified or anonymized dataset can be used without triggering data protection laws, given the risk of re-identification. Moreover, certain collective dimensions of or effects of such data processing should also be kept in mind, certainly when considered together with data provided by similar individuals. The data concerning a person, once included in a training dataset, contribute to enabling inferences concerning a group of people. For example, the group of all the individuals who share the similarities supporting the inference. Therefore, we may say that the set of all such records affect the common interests of the group in which that person is included. And all this brings us to the issue of lawfulness of personal data processing for AI development. One of the main difficulties that arise in data processing for AI development relates to the lawful collection and processing of databases that serve for AI design, training, and testing. For those jurisdictions that follow the European model, the European data protection framework, the collection of this category of data should comply with a set of data protection principles, including the existence of a lawful ground for data processing. One of the fundamental pillars of the right to the protection of personal data is the principle of lawfulness, which means that the processing of any data concerning a natural person requires the prior consent of the data subject or another specific legal ground. Although there is no hierarchy among the different legal bases for data processing, in doubtful cases, consent is generally understood by data controllers and AI developers as a preferred or default choice for lawful data processing. And we can see here the influence of developers that are located in the United States when they follow the principle, the concept of notice and choice as the main lawful basis for data processing, personal data processing. Although and in that sense, we can see that a concept in big data context implies a lot of challenges. AI developers, for example, are confronted with the need to collect multiple consents from different data subjects, ensuring that these authorizations comply with the validity criteria established in the data protection regulation. Additional data subjects have the choice to revoke the consent they had initially granted. Thus, the exercise of this right could affect and compromise the operation of the AI systems, especially in those cases in which input data has been subject to extensive processing operation or mixed with other information contained in different datasets. We also need to consider here other aspects, for example, the problem of concept fatigue that can affect in some ways how we can see concept as a preferred choice of a safeguard for data subjects. In that sense, given the existing difficulties involved in obtaining a meaningful data subject consent in the AI development context and relying on this consent as condition for processing personal data, the legitimate interest pursued by the data controller or a third party emerged as an adequate option in contrast that followed the European personal data protection regulation model. GDPR-like data protection laws. establish or incorporate a legitimate interest as a new lawful basis that could help to meet the challenge of quality, quantity, and relevance of data created for AI design, training, testing, and validation purposes. It is important to keep in mind that this lawful ground rests on a balance test, which requires careful weighing different interests and conflicting rights, centered on two fundamental elements: the necessity of processing the personal data to accomplish a specific purpose, and the prevalence of the legitimate interest invoked, considering the circumstances of each case. Here is particularly important to determine the potentially harmful impact of a given AI system, as well as its objectives on its relevance to the satisfaction of a general interest, for example. The legitimate interest must not be understood as a sub-option for AI developer. It means that data controller takes on more responsibility. As a counterpoint to its flexible nature, processing personal data based on that legitimate interest requires that data controllers to carefully consider the purpose of these operations, the data necessary for its fulfillment, and the various rights and freedom at stake, considering the particular circumstances of each case. It's a case-by-case lawful basis. It's important to keep in mind the context, the expectations of the data subject, and all the environment that surround the data processing operation itself. Here, the most important, the substance of my paper. It's noteworthy that in Latin America, where the influence of the European data protection system predominates, various different national legislation have implemented or are discussing major amendments to their personal data protection regulation frameworks, and these new laws are inspired by the GDPR rules, leading to a recognition of the legitimate interest structured around the balancing test as a lawful ground for personal data processing. And in this case, we can appreciate, starting by the standards for data protection for the Ibero-American states, that all these standard and all this the Brazilian general data protection law and Argentina's and Chile draft bill to update its personal data protection law are incorporated this lawful basis following the European vision to the European approach, and this legitimate interest structured around this concept of balancing test. Well, it's possible to understand that the legitimate interest that has been incorporated in different Latin American regulation, data protection regulation, can be useful for AI development, training, and validation purposes. If we consider that the Latin American countries are moving forward decisively towards GDPR-like data protection legal frameworks, it's possible to establish that the region is moving, it's configuring, is approaching to the legitimate interest as an unlawful basis that is flexible enough in order to consider AI development proposals as an lawful interest. In this case, for example, Brazil, that configure the legitimate interest or incorporate the legitimate interest in Article 7 and Article 10. It's possible to see that the use is possible, that the use of artificial intelligence for several purposes is legitimate and supported by law. Here it will be important to see how the Brazilian DPA will interpret we give some guidelines regarding the adequate interpretation of these provisions, and if possible, they can incorporate, for example, the case of data AI related proposals as an legitimate interest. The other case that is noteworthy or is important to consider is the Chilean case, because the Chilean case is incorporating a provision that states explicitly that can exist a legitimate interest in data processing operations for exclusively historical, statistical, scientific purposes, or for studies, for research into public interest. In that sense, it can be it's possible to establish that the legitimate interest that follow the balancing test established in the European legislation can be interpreted in such a way, following the European approach, and considered in conjunction with this provision contained in Article 16 quinquies, it's possible to conclude that legitimate interest is a lawful basis appropriate for AI development proposals. In conclusion, given the difficulties that imply the use of or relying in consent as a lawful basis for AI development proposals, we need to pay attention to legitimate interest, this new lawful basis that has been incorporated in several Latin America data protection laws, and given its flexibility, given the balancing test, it's possible to use legitimate interest as a lawful basis that can allow us to interregion to develop best or more trustworthy AI systems. In that sense, we need to consider or to pay special attention to the Brazilian case. It's necessary to pay attention to following years how the Brazilian DPA will interpret provisions contained in the General Data Protection Law, and how these guidelines provided by the Brazilian Data Protection Authority will be very useful for other countries which are incorporating legitimate interest provision in its data protection laws and regulations. This is in general terms the main notion, ideas, conclusions contained in my paper. There are obviously I delve into all these ideas in more detail in my paper, but I will be happy to hear your comments, to hear the questions regarding the ideas exposed here. And well, thank you for your attention.
Thank you very much, Pablo. This is a very interesting and important topic, and so your paper, your presentation are especially welcome, because indeed now that legitimate interest is presented as one of the possible legal bases, for example, in Brazil, the concern is that it is treated as a soft option, as you mentioned. So somebody calls it a check, a white check, so a blank check that basically companies can use to justify their operation without necessarily providing the adequate level of transparency, because there is no legislation, there is no guidelines regarding how this legitimate interest should be operationalized. So I see your attempt in the paper as trying to convey some of the lessons that have been learned in the GDPR, similarly perhaps to what Katarina and her co-authors have done. And I think this is very important in this regard. Now, one of the questions that I think are more important here is with regard to how we scrutinize the implementation of the legitimate interest test. So I think that the challenge that has been already mentioned about the burden of proof is significant in that regard. And one suggestion that has been made here in at least the Brazilian literature, I see that you cited Bruno Bioni, for example. He was just here last week on Friday presenting his new book on accountability. And one of the suggestions that he made in that book is that the impact assessments as well as the legitimate interest assessments should be made public. Now, there was not a lot of discussion about what are the circumstances, if this should apply to all situations. But I wonder how you would react about this proposal that companies should make this legitimate interest assessment public, so that data subjects that are affected can verify whether this is done properly, the test and the implementation of this test is done properly with regard to their processing operation. Like the previous speakers, I will make a couple of questions and then I will give you the floor. So if you can wait patiently, I will appreciate. The second aspect that is important in this regard is, in some legislation, the law already provides some typified cases of legitimate interest, of what constitutes a legitimate interest. For example, first-party marketing in the GDPR, and other laws might have, even the Brazilian legislation has some examples. So would you think that a presumption for testing of AI, training of AI, would be a good way forward? So would you suggest that this should be done in new legislation that comes up? Also, another important point that would allow a better implementation of the test is to define a role for certification bodies and codes of conduct in defining how the legitimate interest test is conducted in specific settings. So, for example, the training of AI for one particular purpose, the educational technologies for children might be different than training of AI for different reasons. So I wonder if you can also explore some of that. And then finally, one thing that I guess it's relevant to all this is the role of privacy enhancing technologies. So, for example, synthetic data and anonymization techniques. So at the moment, for example, in the Brazilian framework, but I think other frameworks in Latin America as well, we don't have detailed guidelines on this kind of technologies. And this could provide some way forward for organizations who want to develop testing of AI, training of AI in line with the principles of the law. So I wonder if you want to comment anything about that. And also something very specific, so to the Brazilian framework, so feel free not to respond this, but we don't have a general right to object as there is in the GDPR. So this is, I think, a challenge with regard to the legitimate interest, because unless the controllers decide to give, as part of this legitimate interest assessment that they do, a specific right to opt out to individuals, then basically they will not have an effective provision that they can invoke in the law to stop the processing operation that they deem not to be in compliance with the principles of the LGPD. So does this give us any lessons or suggestion on what we want to say about other frameworks in the region? Should they give a right to object, or can this be developed as part of, the guidelines of the authorities? So also that is something on which you might want to comment. So thank you very much. These are the questions.
Thank you, Nicola. You posed a ton of questions, but I try to address all of them. First, regarding transparency and legitimate interest, I think that legitimate interest is directly linked to transparency. It's necessary for legitimate interest to have a big to put a lot of attention to transparency, and that's the reason why it's so important regarding legitimate interest, the right to object. Legitimate interest without the right to object it's incomplete. And I would say that in the Chilean case, for example, you can see that a lot of discussion regarding how to address correctly the right to object provisions in order to make a legitimate interest an adequate lawful basis in order to protect data subjects. And I think that is very important, because when data subject trying to exercise the right to object, usually we can see how all these obligations regarding with transparency to information are in action, and that is the instant, the moment in which the data controller must provide all the information regarding the legitimate interest impact assessment. For example, in that case when the controllers show all the documents, illustrating how was made all the legitimate interest evaluation, how he or she ponderate the impact on data subjects, the provisional balance of interests and the additional safeguards applied by the controller to prevent any undue impact on the data subject. Is during the exercise of the right object when we can see that. That's the reason why it's very important to consider is like the legitimate interest with first the balancing test and second with the right object. That's very important. Regarding the presumptions of legitimate interest, well, I would say that if the presumption implies that that the balancing test will not take place, we will have a problem probably, because it's impossible to understand the legitimate interest without the balancing test. And we can see that, for example, the United Kingdom in the amendment to its GDPR, the UK GDPR, is trying to establish some kind of legal presumptions regarding the use of legitimate interest, for example, in order to avoid bias in AI training data sets. But the point is that the question is, it's possible to understand or to try to exclude the balancing test in any case when the AI on a data set will be used for purposes of AI training validation in order to avoid bias. I don't know. I mean that in some way this kind of provision affect seriously the very nature, the core of the legitimate interest as an protection to the data subject. Regarding the role of certification bodies, well, I think that the role of certification bodies is very important if we consider the legitimate interest impact assessment in order to prove that this impact assessment was carried out by the data controller. That's I see that the role of certification body in that sense is very important. But the challenge here is how to give some kind of rules, in order to determine how the certification bodies must proceed in order to ponder, to assess, evaluate this kind of lawful basis, and that is a big challenge, I would say. And finally, regarding the use of privacy enhanced technologies, synthetic data, I think that is very important because, as you know very well, artificial intelligence systems require a huge amount of data. And if you consider all the amounts of data, all the terabytes of data that the development of a particular AI technology requires, the problem is what we are going to do with all this data when collected in order to prevent risk of some data breaches, in order to comply with data minimization principle, propose a limitation principle. And in that sense, I would say that it will be very important when collecting this data to try to trying to submit this data to some kind of privacy enhanced technologies, because in that case, the data controller can in some way prove that he is the data controller, he or she is doing is taking care of data, is taking all the safeguards in order to that are necessary in order to comply with all the provisions regarding with this lawful basis. And remember that this lawful basis is particularly linked with data protection by design and by default. And I think that if you consider the PETs, privacy enhanced technology, synthetic data, you consider the principle of data protection by default upon design, and the legitimate interest, the core, the very notion of this legitimate of this lawful basis. In that case, we can see that probably this lawful basis will be adequate, will be safe, and will be trustworthy for data subjects, for DPAs, and probably for courts if some kind of data processing activity is challenged in court.
Fantastic. So I hope that they're watching us and they are following this advice. Now there's a lot that is being recommended here by our papers. I hope that everybody can check the full papers. But thank you. I think is a very extremely important topic, and now we have passed our scheduled time, but there were a lot of issues of translation and video, sounding, etc. So please don't feel rushed. The next speaker, but we'll move on with the plan as usual. but let me introduce the next speaker. Thank you very much, Pablo, once again. The next speaker is Luciano Freitas. He co-authored the paper with Ronaldo de Moura on aesthetic normalization of gender in the Instagram application, a portrait of the Brazilian woman. And Luciano is a regulatory specialist and senior advisor to the Board of Commissioners of the Brazilian National Telecommunication Authority, so Anatel, and he is a research fellow at the Center on Law and Regulation. Luciano, thank you very much. You have the floor.
Thank you, Nicolo. And also thank you all the speakers and all the fellows that organized this presentation today. I know I'm the last one, and I will try to package my presentation in a 10-minute speak. I will share my screen, and just if you can let me know if you can see it.
Yes, we are seeing it.
Okay. So today's presentation is about experimental work we did. It's kind of application. Basically, it is an application of certain concepts and ideas we heard today along the morning. We will talk about the aesthetic normalization of gender in the Instagram and how it portrays the Brazilian woman. Well, this paper is already published, so that will save some time. And I will just invite you guys to take a look in the published version of it, where I focus some theoretical part and like regulatory part. I will not approach in this speak today, just to save time, but the full paper is already available on the internet. Today's presentation, I will talk about this aesthetic normalization of women in the Instagram, and this whole idea is mainly settled on two theoretical background. That's social role theory. That's basically the division between women and men roles in all sorts of social environment, and in this particular case, in the web environment. And also the computer vision, that's a theory from the computer science. And this is kind of attempt to connect the technology and the psychology in one single paper, and all that surrounded by this debate on artificial intelligence, data protection, privacy, and so on. Well, the internet is a natural locus for research, and social media in particular has provided a lot of data for social analysis. And in Brazil is one of the main producers, the main users of social medias in the world. This is a data from 2022. And Brazil is top ranked here in the first place. And the Instagram itself is one of the most influential social media in the digital culture. It has around above 1.2 billion users worldwide, and most of them are young people, around 90% according to statistics in 2021. And this is a platform that's all based on artificial intelligence algorithms that drives large-scale content production and reproduction. I was not familiar with Instagram before this research, and just make a quick overview of that. Instagram is a application that you can access through your mobile phone or your computer. You basically create an account, and all the memories of your consultations are lined up to show you the content based on your particular interests. For this particular project, I created an user. So this is a user in its first consult to the Instagram. There is no memory. It's a kind of an user in his or her first usage to the data. Once you created that, you start to search for keywords or trending topics. And then the Instagram show you an album of photos. And since this is the first usage of it, then Instagram decide what will show first. So there is no memory. And this is important to our application here, to our research. Well, and then you will start to make consultations for trending topics, and it has a feature that's called Infinity Scroll that basically shows you a never-end list of photos. And based on your experience of using it, your memory of using it, likes, touching the screens, and so on. And again, since this is a new user in this first consult, then we rely on what Instagram decide to show us. So going into the experiment. So this methodology is set on two-stage methodological approach. The first one is the sampling strategy. And for that, we use the batch data collection algorithm, a web scraping application that use this new user to go inside the Instagram and to download a batch data that's a huge quantity of data to my computer. This is the first step. The second step is to classify these images. And to the purpose of this study, we just selected the woman image and then classified this data set on certain features we pre-selected. To pre-select the features, we did a review of the literature to show what are the most common features that are expressed in the literature. And then we did a extensive review of the literature on women and connected ideas related to stereotypes and women and a sort of information from academic source. And then we decided that face and body images, clothes types, and age range are mainly referred in the literature. So then we selected those features to classify our meta images album. In total, we got 22,000 Instagram top ranked meta images. That is an arbitrary choice based on the capacity of processing from my computer. And basically, we did consults for 4 trending topics: Sucesso, Brazil, Saúde, and Amor, that is success, Brazil, health and love. That were the main trending topics, the hot topics at the day we did the research. The algorithm we use it to classify them is based on these convolutional neural networks, and we use the Python TensorFlow package to process all the data. Basically, it is an optimized application of convolutional neural networks that takes small pieces or pixels of the image and compare them with a trained data set to classify them. We used 125,000 images for training our model, and these are the source of image, all public image database that covers the gender type, the face, the age range, and the clothes. And since this is based on a database of images, we didn't make any discussion on certain gender debate that could not be evaluated differently from the image the algorithm identified. We did an offline processing system that basically ran in the computer in a large scale meta images data bank. after running the model, we discovered that although that prediction were quite accurate, there was still impossible to get a full accurate classification of it. And one of the main reasons was that the data set we used to train the algorithm did not have the characteristics of the Brazilian woman. So these are international database, and that did not allow us to have a local application of it. And then along the process, the researching process, we decided to include a new methodological step that was to make an auditing of the results. And then we selected a multi-gender mix of reviewers. And we did a one-day workshop to reclassify the images and then to get a better result. And these are the results for the classification. We got a total of 5,621 meta images out of those 22,000. So we just discarded the man image and all the other meta images that didn't have woman in it, maybe text or some other thing that were not human picture. And for the meta image of woman, majority are images of full body, and these are the common features for all the trending topics. And out of this full body pictures, we identified the predominance of swimwear or sport outfit. I mean, the women were using this kind of outfit out of 13 clothes we got in our training model. Out of 13 clothes types, we got the predominance for the swimwear and sport outfit. Regarding the age range, majority of women portrayed are in the 30 years old. That's except for the trending topic love, that we got majority of people from 20 to 30 years old. Then along the paper, we got a better discussion on that, but we try to highlight two sources of potential bias. That's the embedded bias within the algorithm. And we report some examples from the literature. This is widely recognized source of bias in the algorithm. And examples dates back from the 1980s. For example, this is a study from a British medical school that identified after investigation that they had some bias against people from foreigner background to be admitted in this British school. So this is a long time embedded bias. And also the deliberate use of certain stereotypes as a marketing strategy by content makers. This, we try to highlight these two sources of bias behind the image classification in Instagram. We also approach certain topics regarding some social dilemmas we are facing today. But when we did this research, this was the hot topic at the time. Research from Facebook that came out to be disclosed by the Wall Street Journal, and one of those conclusions of that research is that more than 40% of Instagram users who reported feeling unattractive said that the feeling began on the app. About a quarter of teens who reported feeling not good enough said the feeling started on Instagram. And this might be related to the mismatch between the portrayed woman in Instagram that we said is above 30 years old, and the users of it, that is majority young people. 90% is very young. Then there is probably a mismatch between what a young woman see and what is what she understands as his own body image. And the conclusion is that we observed that this is an analysis of the top-ranked meta images from Instagram for a woman. The typical portraited woman in Brazil in the Instagram, the Brazilian woman in the Instagram are around 30 years old, shown in full or partial body and dressed in swimsuits and jean outfit. This is the average woman, the typical woman. And the empirical evidence shows that the recurrence of women's aesthetic stereotypes in top prioritized Instagram content. And there are several reasons for this bias, and we got some evidences on the possible unconscious bias inside the algorithm itself, and also the commercial use of certain stereotypes to potentialize the market of the content maker. And to finish, this is a mix of technology and psychology analysis of complex social issues from the social medias, and we found that that has a strong potential to be developed and to produce quantitative content for the studies and discussion in this topic of artificial intelligence and all sorts of discussion from data protection, privacy, fairness, and so on. So, thank you very much.
Thank you. Thank you very much, Luciano. That's very interesting applied research that we have witnessed here. So basically, you are using AI to detect bias in AI that is in turn used by the algorithm, by in this case, Instagram. I think that's a very promising method of research, as you point out in your conclusions. However, at the same time, this is something that researchers around the world are not always able to do because of the lack of a legal framework governing, for example, data scraping and reuse of this data. So as you might know, there is a similar type of work that was conducted by Algorithm Watch with regard to Instagram as well, but it was not focused on women. It was focused on the incentives that are there to expose parts of the body, and so they showed that people who expose more, they were ranked higher and they were appearing more, reaching more users. What happened at some point is that Facebook sent, or Meta sent a notification that that basically they were concerned about how this research was being conducted, particularly about the fact that they might not have the consent or a valid legal basis for processing the data of third parties. So I wonder if this is a concern that affected you at all in your research, and how you addressed it, or how you think that the regulatory framework here should encourage or regulate this type of research, because I do think that it's an important way for us to scrutinize what's going on, but at the same time there are many trade-offs and complications, and so I wonder how you see us moving forward in that regard. Another question that I have is, so what is the lesson besides the usefulness of this approach? Seems to me that what you're suggesting here is that there should be more diversity of the type of women that are portrayed on Instagram. Is this a matter of data inputs or more like an algorithmic diversity? So in fact, it might be a natural consequence of everything that was being given to the Instagram algorithm. You must be just fed by a lot of these kind of photos, but it might be more like an algorithmic issue. And is the regulation that we have in place sufficient to kind of, if properly enforced, encourage that type of diversity, or maybe we are too focused on specific categories. So if there is some discrimination in terms of gender or race, that's something that we can address, but maybe we don't have the proper tool right now to tackle the issue that you are kind of pointing at here, which is like you're only producing stereotypes all the time. So I think these are the two most burning questions that that came to my mind as I was listening to your presentation.
Yeah, this all concerned us along the paper production and the research itself. We didn't got a notification formally, but we got our account blocked direct. This account, but then we tried to manage, and we offered some explanation. Then they opened that again. There are some things here. The social media provide you this capacity to make inverse engineering and to gather data. If this algorithm are running in a bank, for example, you could not manage to get any evidence, and you just guess. We try to make some quantitative reference on what is shown. We try to count the results. We try to classify them. We try to create a reasonable approach on that. And just to be clear, this is a picture of that day in Instagram. This algorithm changes every day. We run the same algorithm during the last Women's Day in this year, and the results were totally different. So we try to get a picture and not a movie of it. This is important to say because, you know, this is a kind of, everyone is learning ongoing learning on that, including Meta and Instagram that have done an incredible work on other fields like race, and there are several reported advances on race and terrorism blocking in their algorithms. So we believe this is an ongoing learning process. We don't have a lesson in terms of regulation or application or some further discussion on stereotyping or the question of woman and feminism on this. We just try to create an awareness of how the social medias have an impact on the audience, and all based on numbers, on quantity, and a significant quantity of pictures we got. So our idea was not to settle any agenda on regulation, but just to create awareness and maybe to educate people about the risks of consuming social media content without a critical reasoning. So this was the idea.
Absolutely, but no, very important research. And I think we will see more of this now that we see regulations imposing some data access obligations, in particular the Digital Services Act, which is going to enter into force very soon in the European Union, as a framework for the sharing of data by the very large online platforms with researchers, so that they can conduct this testing and you know, generate awareness about some of the risks that are involved. And the same provision, well, similar provision is also contained in the proposal for legislation on fake news, the proposal 2630 of 2020 here. But of course, this will be rediscussed after the election, so we'll see if it will become law in Brazil in this, at least in these terms. But I think there is a lot of potential for this kind of research, and we hope to encourage more of it in the next CPDP Latam editions. So I thank you very much for participating in this. I hope you can also come in the next conference to discuss the promises of this kind of approaches. I think that's a very, very interesting approach that I'm also sharing. We have a paper on that as well. So then we can exchange some emails and discuss on this. But I want to take the opportunity to thank everyone who has stayed with us. It was a very interesting set of papers, and I'm sure that people will go back and watch the recording, and we will continue our discussions in the next editions. So with that, I close this session, and I remind everybody that in about 15 minutes, another session starts. That will be in Portuguese, and it will be with the papers that have been published in the Revista Brasileira of the Direitos Fundamentais e Justiça, and they're already online, so you can check them out. Our paper for this special issue are not all yet published, but we will post them on the site of CPDP Latam by the end of the day. So thanks everybody for watching, and for those who are coming back in 15 minutes, have a good, very short lunch break, and see you all soon. Bye-bye.
Bye, thank you.